Dear students, now we are going to discuss the Panchayati Raj in India and the 73rd Constitutional Amendment Act. Local government is an integral part of the three-tier system of our government in our country. The other two tiers being the union government at central level and the state government. Local government is at the bottom of a pyramid of governmental institutions with the national government at the top and the intermediate government, that is the state government, occupying that middle range. The Panchayati Raj generally refers to the system of a local self-government in India introduced by a Constitutional Amendment Act in 1992, although it is based upon the traditional Panchayat system of Asia. This Panchayati Raj system was formalized in 1992 following a study conducted by a number of Indian committees on various ways of implementing more decentralized administration. Mahatma Gandhi advocated Panchayati Raj as the foundation of India's political system as a decentralized form of a government in which each village would be responsible for its own affairs. The term for such a vision was Gram Swaraj, that is village self-governance. Instead, India developed a highly centralized form of a government. However, this has been moderated by the delegation of several administrative functions to the local level, empowering elected Gram Panchayats. There are significant differences between the traditional Panchayati Raj system that was envisioned by the Mahatma Gandhi and the system formalized in India in 1992. As of now, there are a total 2,67,428 local government bodies, of which 2,63,771 are rural and 4,657 are urban. Of the rural government, 632 are Jilla Parishads at the district level, 6,672 are Panchayat Samitis at the block level, and 2,55,466 are Gram Panchayats at the village level. If you look into the history, the Panchayat Raj system was first adapted in the state of Rajasthan in Nagaur district on 2nd October 1959 based on the recommendations of Balwant Rai Mehta. During the 1950s and the 60s, other state governments adopted this system as laws were passed to establish panchayats in various states. The second state was Andhra Pradesh, while Maharashtra was the 9th state. It also founded backing the Indian Constitution with the 73rd Amendment in 1992 to accommodate the idea. Local government operates both in urban and rural areas and is therefore designed as urban local government and rural local government respectively. The former manifests itself in urban local government institutions such as the municipal corporations, municipal committees, town area and notified area committees, and the later in rural local institutions comprising Jilla Parishads, Panchayat Samitis and Gram Panchayats. In June 1990, under the chairmanship of Prime Minister V.P. Singh, a conference of the state chief ministers was organized to discuss reforms in the Panchayat Raj structure. On the basis of the suggestions received, the cabinet formulated the 64th Constitution Amendment Bill, which was introduced in the Lok Sabha in September 1990. However, due to the political upheaval that followed, the amendment could not get through. The Congress government and the leadership of P.V. Narasimha Rao, which took charge in June 1991, modified the amendment drastically and reintroduced it in Parliament in the shape of the 73rd Amendment. It was passed by the Lok Sabha on 6 December 1992 and by the Rajya Sabha on 23rd December 1992. The amendment came into force on 24th April 1993, on which date all provisions in various state acts that were repugnant to the provisions of the constitutional amendment ceased to remain in force. This amendment was extended to panchayats in the tribal areas of the 8 states, namely Andhra Pradesh, Gujarat, Himachal Pradesh, Maharashtra, Madhya Pradesh, Odisha and Rajasthan beginning of the 24 December 1996. This amendment contained provision for devolution of powers and responsibilities to the panchayats, both for the preparation of economic development plans and social justice, as well as for implementation in relation to 29 subjects listed in the 11th schedule of the Constitution and the ability to levy and collect appropriate taxes, duties, tolls and fees. The Act aims to provide a 3-tier system of Panchayati Raj for all states having a population of over 2 million to hold Panchayat elections regularly every 5 years, to provide seats reserved for scheduled castes, scheduled tribes and women, and to appoint a state finance commission to make recommendations regarding the financial powers of the panchayats, and to constitute a district planning committee to prepare a development plan draft for the district. Many states had by then amended their own acts. Under Article 243G, the Constitution has given authority to state governments to endow Gram Panchayats with necessary powers to carry out their functions. States are empowered under Article 243H to authorize Gram Panchayats to levy, collect the appropriate taxes, duties, tolls and fees apart from giving the grants in aid from the consolidated fund of the state. Another provision, that of the Article 243I, provides for the constitution of a state finance commission for every 5 years to review the financial position of Gram Panchayats and to recommend ways for implementing the provisions of Article 243H so as to improve the financial position of the latter. The Gram Sabha, the General Assembly of the villages, have a key role in effective functioning of Gram Panchayats through, among other things, discussion of the annual financial statements of Gram Panchayats. The main components of fiscal decentralization comprise expenditure and revenues transfers to local governments and subnational borrowing, which is not a regular feature of Panchayati Raj institutions in India. The main provisions of the 73rd Constitutional Amendment Act. The main provisions of the 73rd Constitutional Amendment can be grouped under two categories: compulsory and voluntary. Compulsory provisions. These are specifically provided for through the Constitution. They are organization of Gram Sabhas, creation of 3-tier Panchayati Raj structure at the Jilla, block and village levels. All posts at all levels with 2 exceptions to be filled by the direct elections. The minimum age for contesting elections of PRIs to be 21 years. Indirect elections to the post of chairman at the intermediate and apex tiers. Reservation of seats for scheduled castes and scheduled tribes in panchayats, both chairman and members, in proportion to their population. Reservations for women in panchayats, chairman and members, up to 1/3 of seats. Creation of a state election commission to conduct elections to Panchayat Raj institutions. Tenure of Panchayat Raj institutions fixed at 5 years, and if dissolved earlier, fresh elections to be held within 6 months. And in order to review the financial position of the Panchayat Raj institutions, each state to set up a state finance commission every 5 years. Voluntary provisions. The implementation of voluntary provisions has been left to the will of the state. They are giving voting rights to members of the union and state legislatures in these bodies, providing reservation for backward classes, giving the Panchayat Raj institutions financial powers in relation to taxes, levy, fees, etc., making the panchayats autonomous bodies, and devolution of powers to the panchayat bodies to perform some or all of the functions suggested in the 11th schedule added to the Constitution through the 73rd Amendment and or to prepare plans for economic development. Powers through 11th schedule are: 1. Agriculture including agriculture extension. 2. Land improvement, implementation of land reforms, land consolidation and soil conservation. 3. Minor irrigation, water management and watershed development. 4. Animal husbandry, dairying and poultry. 5th. Fisheries. 6th. Social forestry and farm forestry. 7. Minor forest produce. 8th. Small scale industries including food processing industries. 9. Khadi, village and cottage industries. 10. Rural housing. 11. Drinking water. 12. Fuel and fodder. 13. Roads, culverts, bridges, ferries, waterways and other means of communication. 14. Rural electrification including distribution of electricity. 15. Non-conventional energy sources. 16. Poverty alleviation programs. 17. education including primary and secondary schools, 18, technical training and vocational education, 19, adult and non-formal education, 20, libraries, 21, cultural activities, 22, markets and fairs, 23, health and sanitation including hospitals, primary health centers and dispensaries, 24, family welfare, 25, women and child development, 26, social welfare including welfare of the handicapped and mentally retarded, 27, welfare of the weaker sections and the particular of the scheduled castes and scheduled tribes, 28, public distribution system, 29, maintenance of the community asset. The 73rd Constitutional Amendment has been heralded as a new era for the Panchayati Raj. The following are the praiseworthy features of the 73rd Amendment. 1. Confers status and dignity on the Panchayati Raj bodies. The constitutional base for Panchayati Raj was required because state governments were not enthusiastic about the creation of Panchayati Raj bodies and to share power with them in their states. In fact, there are instances where some states have taken back powers from the Panchayati Raj bodies. Status and dignity to Panchayati Raj bodies to make them viable and responsive institutions is essential. They should find a place in the Constitution of India. In our Constitution, local self-government and a Panchayati Raj is a state subject and the central government cannot pass any legislation unless the Constitution is amended. The 73rd Constitutional Amendment Act 1993 was passed thereby conferring the much needed status and dignity to Panchayati Raj bodies. Ensures continuity. Prior to the 73rd Amendment Act, the state government had the discretion to supersede Panchayati Raj bodies and conduct elections at their will. There have been innumerable cases where the Panchayati Raj bodies have been superseded on a partisan grounds and elections have not been held for many years. The 73rd Amendment said that the elections to the Panchayati Raj bodies would be held mandatorily every 5 years. This is a commendable step. Moreover, the amendment provides for an election commission for each state for the conduct of the elections to the Panchayati Raj bodies. This ensures impartial and fair elections. Ensures participation of weaker sections and the downtrodden. The Act provides for mandatory reservation of seats for the scheduled castes, scheduled tribes and women. This is indeed commendable as it ensures the participation of the weaker sections. Ensures adequate sources of finance. Financial paucity has been one of the main causes of the failure of Panchayati Raj bodies in the past. To remove this hurdle, the 73rd Amendment empowers the panchayats to levy and collect appropriate taxes, duties, tolls and fees. According to the Act, they would be entitled to grants in aid from the consolidated fund to the state. To ensure adequate finances, the Act also said that the state governor has to appoint a finance commission to review and advise the state government on the principles of governing distribution of funds to the panchayats. The state governments also would devolve power to the panchayats to prepare plans for economic development and social justice. Significantly, a whole new schedule called the 11th schedule has drawn up to ensure a better utilization of central and state funds. The schedule contains entire agriculture and allied activities, minor irrigation schemes, land reforms and improvement of small industries including food processing, cottage industries, rural housing, drinking water, rural electrification, non-conventional energy programs, poverty alleviation programs, primary and secondary education, vocational education, health and family welfare schemes, public distribution system, welfare schemes for weaker and handicapped sections, etc. This Act protects the autonomy of the states while ensuring uniformity. Panchayati Raj is a state subject and a legislation by the centre in this area amounts to transgression on the autonomy of the states. However, the 73rd Amendment Act has incorporated adequate provisions to protect the autonomy of the states. For example, supervision and control of Panchayati Raj elections has been given to the State Election Commission. Framing of laws relating to audit and accounts has been left in the hands of the state legislatures, and power of appointment of a finance commission to review the financial position of panchayats and recommend principles, government distribution of taxes and grants in aid between the states and Panchayati Raj bodies has been given to the states. Even composition of these panchayats has been left to the state. Thus, states have not been undermined by this amendment. These are all salutary provisions. The 73rd Amendment suffers from certain lacunae. Some of them are: the functions, powers and resources of the panchayats are not enumerated clearly. A major lacuna in the Act has been that it has little to offer to the panchayats by way of functions, powers and resources to shape them up as units of self-government. This task has been left to each state legislature to determine, and past experience has shown that the states are always reluctant to part with their powers. Thus, the discretionary provisions by their very nature may defeat the much avowed purpose of the Act, that is, creating genuine units of a local self-government. Leaves a scope for misuse of the rotation system of reservation. The reservation scheme of the office of chairpersons of panchayats in rotation may be misused by the party in power at the states levels to weaken the stronghold of other opposition parties in regions and panchayats of the state. By invoking the rotational provisions whenever and wherever their position is weak, the ruling party may gain an upper hand over the opposition parties. This may create unwarranted tensions. Voting rights to ex officio members defeat the purpose of the decentralization. The Act has given voting rights to the ex officio members, that is, MPs and MLAs in the Panchayati Raj bodies. This could lead to the overriding domination of these institutions by the legislatures, thereby going against the intention of decentralization. Fosters rigidity in functioning of Panchayati Raj. The 73rd Amendment Act dispenses with the flexibility of structure of Panchayati Raj. The question, such as 3-tier or a 2-tier system, the extent of mode of reservations etc. are decided in a uniform pattern for the entire country. This inflexibility may cause great harm. Some states like Kerala, West Bengal, Karnataka and Andhra Pradesh have adopted the 2-tier system after prolonged discussions and experimentation, as it suited them better than the 3-tier system. But the 73rd Constitutional Amendment Act makes it obligatory for every state whose population is above 20 lakhs to have a 3-tier system. This rigidity may hamper the effectiveness of the Panchayati Raj bodies. Fifthly, discretionary nature of functions to be devoted on the Panchayati Raj bodies by the states may defeat the purpose of the Act. Although 11th schedule of the Constitution contains 29 items which can be handed over the village panchayats, it has been left to the discretion of the state to devolve any or all the functions. Previous experience indicates that the states are always reluctant to part with their functions. The 73rd Amendment Act has not offered a remedy to this situation, as it has also left it to the discretion of the states. Serious doubts are being expressed whether the functions will be devolved at all in practice. Sixthly, fails to mention the role of political parties. Further, the Act has failed to mention about the role of political parties. Neither the Act specified their role nor mentioned about the working of political parties. Likewise, it is completely silent about the relationship between Panchayati Raj bodies and local bureaucracy. In the yesteryears, the local level bureaucracy was instrumental in creating and spreading the anti-Panchayati Raj climate, which led to their failure. If the control of bureaucracy in Panchayati Raj institutions is not given to the local leaders and kept in the hands of state governments, then Panchayati Raj is bound to fail. The Act is also silent about the exclusive jurisdiction of panchayats. While the states in the Constitution have areas of exclusive jurisdiction with the legislative, executive and judicial authority. The 11th schedule mentioned in the 73rd Amendment is not mandatory but only advisory in nature. It does not specify the division of spares, only gives the number of development activities considered suitable for panchayats. Inadequacy of staff has seriously affected the functioning of the Gram Panchayats, whose expenditure needs are rising due to the requirement for additional administrative, trained and technical staff for schools, water supply, communications, accounts, tax collection, sweeping, drain cleaning, etc. Staff costs can be reduced by attrition, maintaining core professional staff and drawing local expertise. To summarize, steps required to make Gram Panchayats financially stronger to meet their needs include a carrots and stick approach. They need a better tax collection authority and capacity, more grants and help with improving accounting and record keeping. But at the same time, they also need to work towards expenditure reform and vitalize service delivery. Linking Central Finance Commission transfers to more effective fiscal decentralization by states would add to the gains. With the recommendations of the Finance Commissions, the financial status of the Panchayati Raj institutions, especially of Gram Panchayats, has been improved so much. Because of this development, the Gram Panchayats are discharging their functional responsibilities in successful manner. Summarizing this, since its inception, the Panchayati Raj system in the country has not been functioning in right direction. Hence, a need was felt to revitalize them and evoke a comprehensive concept of Panchayati Raj, which should clearly mention the role expected from Panchayati Raj bodies. The Constitutional 73rd Amendment Act is certainly an attempt, and it is hoped that it will go a long way in revitalizing the Panchayati Raj for decentralization and rural development.